Well, we only have one argument today, and that is Hilton versus Villoni. And you will have 15 minutes. It's all yours, okay? And
Good morning, everybody.
good morning. I just want to remind you, we're videotaping, so you know, stay behind the dais there, not the dais, whatever it's called. Anyway, stay behind that thing, the podium. And, you know, please don't mention children's names and so forth, because, or victims. Okay?
Okay.
All right. You use
Thank you.
initials or just refer to them in that manner. Okay, thank you so much. And you may begin.
Good morning. My name is Paul Grant, and I am going to represent Mr. Vincent Villoni's appeal here today of the magistrates and judges' decision for a CPO against himself and for Terry Hilton and his son Thomas Hilton, who's an adult. Your Honor, this matter, I want to first describe to you the layout of the land of this particular situation. Mr. Philip Stone owns 300 acres of property in Medina, all farming land, soybean. The main property that my client was living in, 6839 Westfield Road, is one of the main houses. There's another property several hundred yards down the property. If I could explain it, is an overlook. But this property of 300 acres is about a mile in each direction. But he overlooks and can see this property. Mr. Phil Stone put him in charge of the property, and he gave him permission to hunt the property. And so he invested a lot of money in a lot of different hunting areas throughout the property, and he had his permission. He'd been there for 10 years. About 2014, Mr. Hilton moves into the second property that's all visible from my client's vantage point. And he, on an occasion, had the opportunity to introduce himself, let him know that he was put in charge by Mr. Stone to make sure that people don't steal any of the vegetation or any of the plants or anything, as well as to let them know that he keeps people off four-wheelers because it's a large area and he wants to make sure that nothing is destroyed. So Mr. Hilton was aware of his position through Mr. Stone. One day in the fall of 2014, my client is hunting, and Mr. Hilton wants to talk to him about hunting. And he says, listen, I have the permission to hunt. You can hunt if I'm not hunting. But just a reminder, there's no four-wheeling on the property. So that is their discussion, very friendly. About 2015, Mr. Terry Hilton, the father, is out on his four-wheeler. My client doesn't know it's him, but it's off in the area not belonging or being rented by Mr. Hilton. So my client goes down an access road that's a private road that he has access to, not on Mr. Hilton's property, and engages him to say, listen, as I remind you, you're not supposed to be riding a four-wheeler in this particular area. That was the end of it. Mr. Hilton would testify that he didn't see a gun on my client. None was shown, none was even alluded to. It was not an angry situation. Certainly I understand Mr. Hilton being frustrated that he was being told by another man not to do certain things, but it wasn't anything of threatening. And this is the testimony at the CPO. The next thing that happened was that in the fall of 2017, some 2 years later, there's another situation where Mr. Hilton and his group, Mr. Terry Hilton and his group, were four-wheeling. My client didn't know that it was him. He goes to investigate, like he's done many, many times, to make sure the property is being protected and things are not being disturbed. Again, he goes on the access road that he's entitled to be on. He sees that it's Mr. Wheeler, recognizes that it was him that was on the area of the property that should have been in. Again, warns him not to be on the property on the four-wheelers. They did exchange some words. Again, it wasn't threatening. It was a disagreement. Because at this time, Mr. Hilton is saying that Phil Stone told him, just tell Vince that I sold you the property, therefore you have the run of the property. My client knows that's not accurate, it's not true. So they're having a disagreement about this fact. In the end of it, they exchanged some words that were not threatening, certainly didn't raise to the level of any kind of harm to any person in the household, a family member, or Mr. Terry. My client, parting word is fine. That was the end of that situation in the fall of 2017. So we have, up to this time, we have the two incidents in December 2015, where he's encouraging him not to drive on the property where he's not supposed to be. And then a second time in the fall of 2017, again, reminding him not to be on the property. Mr. Hilton is not in fear that anybody's going to hurt him and his family or household members. It's an argument. It's understandable that a grown man may be frustrated by those type of conversations, but nothing more than that. It's a legitimate legal thing that he's doing on behalf of Mr. Stone.
Didn't Hilton testify that a gun was pulled and your client threatened to kill his wife?
Your Honor, that is the situation that occurs on July 3rd, 2018. That's the third
That's the next one.
interaction, yes.
Okay.
I'll get right to that, Your Honor. So I just laying out what is alleged as the pattern of conduct that the magistrate relied on, and trying to explain that this was not a threatening or have people believe that there was any cause of harm or threat of cause of harm or trying to put them in any fear, as well as mental health disturbance or distress. The situation that occurred on July 3rd of 2018, my client is with his wife at their property. As I said, they have an overlook of all the entire property as they watched the fireworks in the dugout on July 3rd. They could see that there were lights from four-wheelers off in the distance that didn't belong to Mr. Hilton. As usual, they go to protect their property and they go down the common road, but they can't see who's coming, but whoever it is goes over deeper into the property and then comes back out. Mr. Thomas Hilton, the son, adult son at this time, has his gun out and is pointing at my client and his wife. My client's trying to get them to put the gun down. Put the gun down, there's nothing to fear here. You're just not supposed to be on the property. There's a lot of screaming negative things. It's in the transcript, it's in my brief, Your Honor. I'm not going to go through what those words were from Thomas Hilton towards my client's wife or him, but certainly beyond in poor taste. But it is a threat to kill my client or his wife. My client does leave, and as he's leaving, I'm sorry, I'll back up. My client does at one point pull out his own gun after the gun has been pointed at him by Mr. Thomas Hilton. But he does pull it out, and things neutralize from that point. They all see the better of their actions, and Mr. Thomas Hilton indicates to my client he's going to call the landlord or the police. And I say the landlord because it's important now. Because testimony is, Mr. Terry Hilton told his son, you only drive that four-wheeler on your property, our property here. You don't have to be out in these other areas. But if anybody asks you, and I'm paraphrasing, Philip Stone sold the property to me, you just tell that to Vince. So that's a common argument that not only Terry Hilton is saying, but now his son is saying. Why I'm bringing that up now is to show that when Thomas Hilton was pointing the gun at my client had to pull his out because Mr. Hilton chambered around his automatic weapon, semi-automatic weapon. His intentions were clear. This could get very dangerous very soon. That's why he pulled his out, to get in front of the gun, pointing at his wife's head, and also to neutralize the situation. But when Mr. Hilton said that he was going to call a landlord, he's disclosed that he knows that he doesn't have ownership to his father, permission to his father. Mr. Stone's the landlord, and he controls what's being done on this land.
Well, what you're talking about, though, seems like those are credibility determinations by the magistrate, the judge.
As far as the ownership?
Well, who pulled the gun, and, who said what, and so
Well, it's undisputed that Mr. Hilton pulled the gun first in chamber. There's no dispute about that.
I understand, but what I'm saying is, it's just still a matter of credibility as to who started and who didn't, just because you pulled the gun. I mean, we'll read the transcript. Speaking of the transcript, I was a little confused looking at the record because the judge said she didn't have a transcript.
Correct. The transcript was ordered for the objection, and it didn't come within the time allotted, and that's why they denied the objection.
Do we have it here?
Do we have a transcript here?
Did you file one with the case when you filed the appeal?
The whole record was filed, yes.
With the transcript?
Yes,
So it's here?
yes.
Okay.
So, Your Honor, my client retreated, Mr. Hilton retreated. They each filed mutual CPOs against the other. This hearing was held, which was based on the testimony that I have displayed with the court here. Your Honor, I am just saying that the magistrate didn't have the competent credible evidence to support that my client engaged in a pattern of menacing behavior. Under 2903.211, menacing by stalking says, no person by engaging in a pattern of conduct shall knowingly cause another person to believe that the offender will cause physical harm to the other person, or to a family member or a household member of the person, or cause mental distress of the person, a family member, household member of that person. Certainly, there's no pattern here. There's no evidence in the first two scenarios that we're just talking about people having a disagreement, which happens every day.
Did the magistrate address a pattern of conduct?
No,
It's not in the entry at all.
it's not in the entry, Your Honor, and as a matter of fact, in the application for it, Mr. Hilton does not describe it as being a threatened or harmful situation. And I'm going to bring up right now that I think that it's equally as important that mediation is not offered to CPO candidates. But the magistrate in this case offered it to both of them. Only my client was willing to go through the mediation process. Mr.
Well,
Hilton.
we necessarily, I'm not sure, can consider that, but at the same rate, I was gonna bring it up anyway, because when I first started reading this brief, it's the first thing I thought of, because we have a mediation program, and I'm on the commission for rules of superintendents for the state of Ohio. And that's one of the things that may be changed in the future is that these neighborhood disputes can be mediated. So again, I'm gonna throw it out. Is that something, you know, at this point, the CPO is almost over.
Right, a few months.
You know, so is this something that, I mean, at this point, maybe you guys can still work out?
Your Honor, I think it's a great idea. As a matter of fact, I can tell you something. Mr. Hilton moved out of his house last July. My client moved in and refurbished it. Mr. Hilton comes by every now and again. I don't know where he lives at this point. But
So you still think it may be necessary?
I think it's possible to look at. I
Thomas
know that
still
Mr.
in the
Hilton.
house? Is Thomas still in the house? Terry
No.
and Thomas both moved out?
They're both gone, yes. My
So no
client
one's
has
in
a
there.
house entirely. I don't think there's anybody in the former house where my client was because of a lead paint issue. So he's refurbished what was Mr. Hilton's home.
When does the CPO expire? Is this going to be moved?
July of 20. It said 5 years or July of 20. And I forget the exact date. I could look it up.
That's another reason why though I was suggesting perhaps mediation.
July 6th.
Of course, you were willing to mediate. It was the other side that was not willing to mediate.
Right.
They're in a different position than now.
I think so. It's just very important that my client not have a CPO on his record. He's an avid hunter. He subsistence.
Are there collateral consequences to this?
There is.
Which are?
He can't have a gun. He can't hunt. He can't protect himself and his family. As I told, there's been a lot of people, strangers, stealing. Who knows what could go wrong?
Well, he didn't have to turn his guns in, right, as part of this.
No, he didn't have to turn them in.
But you're saying if he wants to buy a new gun, he won't be able to.
Right. He's had to remove the guns he had. And he's not been. That's all I have.
Any questions?
The rest of us, I agree.
All right, well then, we will take the matter under advisement, and as you know the procedure, we will prepare a written opinion and send it to the parties, and also we'll release the opinion on our website. Now,